War is rarely won quickly and without some bumps along the way. Hello, my friend. Perez Hilton here, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. As I told you last week, the New York Times filed a motion to dismiss to be removed from Justin Baldoni's lawsuit against Blake Lively. He is suing the paper for libel and a bunch of other legal jargon, okay, including false light invasion of privacy, promissory fraud, and breach of implied in-fact contract. The paper argues that Baldoni and his lawyers did not make any viable claims nor prove true cause against them in his amended complaint. And in addition to that, lawyers for the Times also submitted a request to pause discovery in the case while the judge reviews their motion to dismiss. And Judge Lyman just gave the New York Times a small victory, agreeing to their request. So, discovery is paused, and the judge in his ruling said, "The Wayfarer parties are unlikely to be unfairly prejudiced by a stay while the court decides the pending motion to be dismissed." The judge adds, "The New York Times did not delay filing its motion. It filed the motion within 21 days of being served. The court intends to address the motion to dismiss promptly after it is fully submitted." Didn't they do that already? To the extent the Wayfarer parties are concerned about delay, they have it within their power to accelerate their contemplated further amended complaint or their opposition to the motion to dismiss. The Wayfarer parties themselves suggest that discovery from the New York Times is unlikely to be You guys, I barely slept last night. I was filming something in Los Angeles. I am running on fumes, but doing my best. The Wayfarer parties themselves suggest that discovery from the New York Times is unlikely to be I can't even pronounce this word. Voluminous. Oh my God, voluminous. Ay, Dios mío. The New York Times has released a statement to the judge's ruling, but before I read that, I want to share some thoughts. I don't know if I agree with this, because what if discovery proves what Baldoni has alleged? That the plantation princess was in cahoots and working coordinated with the New York Times for a while before they published their article about him. We should know that. His team should confirm that before the judge rules on whether or not to dismiss the Times. But then again, even if the judge dismisses them from the lawsuit, he can always just refile solely suing them, which is what he had originally done before he included them in the amended complaint. We are going to be legal experts by the end of this all. We already are. You more than me. I gotta say, you guys are so smart. All right, the New York Times has responded to the judge saying, quote, "We appreciate the court's decision today, which recognizes the important First Amendment values at stake here. The court has stopped Mr. Baldoni from burdening the Times with discovery requests in a case that should never have been brought." I don't know if I agree with that. Especially if they prove, and it seems likely that the New York Times did cherry pick texts and presented information in a way designed to make him look bad. That doesn't seem very fair or objective to me. Thoughts on this latest development? Let's discuss in the comments section.